Hello there, I am EE Abdul, and today I shall be talking about contracts. A lot of us have been engaged in one contract or the other, and some of us end up in litigation chamber instead of reaping the dividend of our contracts. The problem with most of us is we don't really understand the basic knowledge of contract before we delve into them. We don't know what a valid contract is and what constitutes a contract and what can lead to repudiation of contract or at what point a party can rescind a particular contract. All these are what I will be taking us through in my videos and they will be coming in sequence. Now, what is contract? Contract is an agreement between two or more persons which the law can enforce. Take that again. Contract is an agreement between two or more persons which the law can enforce. Simply put, any agreement between two or more persons that the law cannot enforce is not contract. So, when you are entering an agreement with a person, do you have the intentions to have legal relations? Do you have the desire that in the event of breach of this contract at one point or the other, then the law should step in to ensure that it is enforced or the terms of the contract is complied with? Now, a lot of us make mistake of entering into contract without forming the intentions to create legal relations, which is very wrong. So from what I've said so far, if you enter a contract and you don't intend to be bounded by it, it is not a contract. Now we have different kind of ways we can make contract. You may wonder, yes, I discussed with my friend to buy something for him, his orally is not reduced into writing. Is it a contract? Now let me tell you one thing. We have oral contract, simple contract, and we have formal contract. Now, for formal contract, it's a contract which must be reduced into writing. It must be sealed, stamped, and sealed. It must be sealed, stamped, signed, and delivered. So it's either it's a formal contract or it's a simple contract, which can either be in writing or in oral. But the most important thing you should understand is there should be an intention to have such contract enforced by law in the event of any breach by either of the parties. Now, for you to have a valid contract, there are 4 characteristics you must see in that contract before you conclude that yes, this is a valid contract. First, there must be an offer. Second, there must be an acceptance. And third, there must be consideration. Finally, there must be intention to create the legal relations. So when there is an offer and there is no acceptance, there is no need for you to say there is a contract. Acceptance can either be expressed or implied, as well as offer. Offer can either be expressed or implied. But in each of these, either expressed or implied, it must be unequivocal, it must be clear, it must be definite. So as wrong interpretation will not be given to it, it must not be ambiguous in any form when you want to enter into a contractual agreement with people. But I will advise you as a lawyer that anytime you want to enter into any contract, you should ensure that your contract is well written and ensure that you contract a lawyer who should help you to prepare your contract documents and ensure that it is properly franked, properly endorsed, properly signed, properly sealed, so that the defect of it will not cost you more than you would have benefited should you even go into the contract in the first place. Now, offer, acceptance, intentions to create legal relations will be discussed in details in our next video. But if you have been refreshed in memory as to what constitutes contracts, then you should like, share, and comment on this video. And in my next video, I promise to tell you in detail what an offer is, what consideration is, what intentions to create legal relations is. I am EE Abdul Esquire saying, stay blessed.